Well, the vision of the judge has to be holistic and not myopic. The spirit of the judge must be liberal, not conservative. The mind of the judge has to be flexible, not rigid. The viscosity of judicial thought should be like water. It cannot be like rock, crystallized by prejudices and biases. So we should be guided by its mandate, the Constitution of India and its philosophy. We should be inspired by its streams and its preamble, because the preamble contains the 10 commandments. To deviate from these commandments is to commit a jurisprudential cardinal sin. Those were the golden words from Honorable Justice Chauhan sir's superannuation speech. And so, hello everyone, you're watching the virtual amicus, and I'm Jay Luda. Well, quoting Justice Chauhan's extracts before him is again a matter of great honor, because joining us today on the virtual amicus is former Chief Justice of Uttarakhand High Court, former Chief Justice of Telangana High Court, former Judge of Telangana High Court, Karnataka High Court, and Rajasthan High Court. So today we are joined by Honorable Mrs. Justice Raghavendra Singh Chauhan sir. He needs absolutely no introduction. Someone who boasts of a brilliant English vocabulary, a tremendous legal acumen, and a wonderful temperament. As a judge, he has had a tremendous judicial career, a wonderful legal career, and under his chief justiceship, he's also flagged off the 5 mobile e-court vans that were equipped with internet connectivity and computers for various districts to start the mobile e-courts in remote villages, so that it's easy for everyone to have access to the internet to courts. So, and today he'll be doing a special session on criminal appeals, how to pursue, how to draft, and how to argue. So thank you so much, sir, for taking our time for doing the session. Anything that you wish to say before you start with this session, sir?
No, in fact, I'm grateful to you for giving me this opportunity of being able to address the young and dynamic lawyers. The young lawyers are the hope of our future. Therefore, it is imperative that they be well prepared, well stocked, and should know how to argue in the court. During the course of my speech, of course, I'll reveal some nuggets and some secrets of how a judge's mind works, which is what is the thing that the lawyers must learn to understand before they appear before a judge. I think it just makes the job a lot easier for a lawyer to know what is expected of him and what is not expected of him in the court. So we'll begin with this lecture on how to prepare and argue a criminal appeal.
Very well, sir. You may proceed, sir.
Okay, thank you. Thank you. Good evening to everyone. And let me just briefly give you a bird's eye view of the lecture that I have prepared. On the topic, how to prepare and argue a criminal appeal, which can be a rather daunting task, especially when you're a young lawyer and you do not have too much of experience. So briefly, I'll be covering about 11 points. First is the first principles of criminal law. Naturally, you cannot argue a criminal appeal effectively until and unless you are well aware of and understand what are the first principles of criminal law. Number 2, how many different kinds of offenses do we have? And why is it that they have been classified into different buckets? Number 3, how does one draft a criminal appeal? Before one can be expected to argue, the first question is the drafting of a criminal appeal while you're sitting in your office. Fourthly, what are the grounds which are available to a lawyer in a criminal appeal? Fifthly, how to prepare for a criminal appeal? How do you go through the records of a criminal appeal? How do you decipher it? How do you organize it? Sixthly, what happens when you have to argue an appeal, not on behalf of the accused or the offender, but on behalf of the victim or the complainant? Because the very mode of argument and the method you will use will completely change when you change your side from that of an accused to that of being counsel for the complainant or the victim. Your hat trick changes. Your hat is no longer that of a defense counsel, but now you wear the hat of a complainant or victim. Seventhly, how do I argue an appeal before the court? How does one begin the opening of the case? What is to be expected when you open a case? And eighthly, how do you prepare for the future cases? And lastly, how does one bind down a court? There are certain tricks that one should know. You may have a very tough judge to deal with, and there are judges who can be skeptical, cynical, hyper-technical in their approach. Now, the question before the council would be, how do I make sure that I can tie down this court and tie down this judge so that he gives a judgment in my favor? So these are the broad points that I'll be covering in my lecture. Now, when we talk about preparing a criminal appeal or appeal of any sort, as you well know, when you appear before the courts, there are two things that are happening simultaneously. One is your knowledge of law, and second is experience of life. And that is what is going to be showcased before the courts. It is not only that your knowledge of law is relevant. At times, what is relevant is your experience of life. How deeply have you studied life? How deeply have you studied characters? How deeply have you studied people? How deeply you have studied circumstances which are brought forth while you're arguing a criminal appeal. And when you appear in the court, please remember what Aristotle said. Aristotle in his book says that there are different ways of addressing a gathering. And he says there are three different ways of addressing any given gathering, and he gives us three separate examples. He says when you address the public at large, as a political leader would, the gist of his argument is emotional. He has to steer the people, emotions. Therefore, he speaks about the history, the present, what is happening, what are the issues, how do you resolve these issues? And he may even play on the fears of the people. Therefore, what he's trying to do is to whip up the emotions of the people, and take the example of Mark Antony's famous speech in Julius Caesar when he addresses the gathering of Roman citizens immediately after Julius Caesar is assassinated and his dead body is lying. And he addresses them as friends, country, and Romans, friends, and countrymen. And he talks about the critical moment in Roman history. He says, now we are faced with a critical moment. He wants to denounce the culprits, but he cannot openly do so. So he is appealing to the emotions of the people. Aristotle says, then there is an address which you give in a parliament, in a senate. And he says there, emotions really do not work. What works is in your rhetoric, in your speeches, what is good for the nation, number one, and what is good for the political party, number two. Number three, a man may be addressing a court of law. There neither the nation counts nor the emotions. What counts are the cold facts of a case, the ingredients of the law, the logic that needs to be marshaled out, the logical arguments. Therefore, he says that you have to custom tailor your speech depending on whom you're addressing and where you're standing, in which forum are you standing. Now, before we go into how does one prepare and argue a criminal appeal, let us first deal with the first principles of criminal law, because these are the cardinal principles of criminal law which you will be dealing with day in and day out. The very first and foremost principle of criminal law is that every person is presumed to be innocent till proven guilty. Therefore, in a common law country, unlike a continental law country, the burden of proving the guilt of an offender lies on the shoulder of the state. It does not lie on the shoulder of anyone else. Therefore, there are certain principles which will now flow from this first principle. First of all, every man is presumed to be responsible for his act, which we term as the individual liability of an offender. Secondly, when that offender is part of a group, whether it be 2 persons or more than 5, what we call under section 34 of IPC, when 2 or up to 4 people are involved, we are looking for the common intention. Under section 149, when you become a member of an unlawful assembly, which is 5 or more persons, we are looking at the common object of the assembly. Therefore, we enter into, from individual liability, we enter into the next stage called the vicarious liability. Under vicarious liability, you're not only responsible for your own act, more so you are responsible for the act of others. You may not be the principal offender who has committed the murder, who has stabbed the deceased, but nonetheless, your very presence at the scene of the crime will make you liable for the liability of that person who had stabbed the deceased. And this is part of vicarious liability. Number 4, every criminal offense has 2 parts to it. What we call the act, which is in Latin term is called actus reus. And secondly, the mental part, which we call mens rea, or the intention. But intention has many different forms in which it can be expressed. It can be expressed as knowledge, as rashness, negligence, fraudulent intention in case of cheating. Therefore, we would have to prove, the prosecution would have to prove the existence of the mens rea. If the mens rea does not exist, then obviously no offense is made out. However, there's another part of liability called the strict liability. And yes, we have a strict liability case even in criminal law. For example, kidnapping. For example, a statutory rape with a minor. There, the intention of the person is not so important. In fact, even if the intention is not proven, the fact is the offense is still deemed to be completed. The other thing we must know about offenses is the different types of offenses which are placed in different buckets, especially in the IPC. There are offenses against property, such as theft, trespass, extortion, robbery. Then there's the second bucket called offenses against the body, such as assault, hurt, grievous hurt, rape, murder, culpable homicide not amounting to murder. Then there are certain offenses which are against the state. They need not be against an individual as such or against a given community, but are offenses under the state, such as sedition, waging war against the state. Surprisingly, there are even offenses against the judiciary. For example, perjury. Giving a testimony under an oath or submitting false document, knowing the documents to be forged or to be false, while during the course of the trial, these are offenses against the judiciary. There's a third categorization of offenses, which is under the CRPC. Offenses have been classified under the CRPC as bailable, non-bailable, cognizable, or non-cognizable. And this is readily available in the schedule that is attached with the CRPC. So whenever you're dealing with any offense, the first thing is please refer to that schedule and see the nature of the offense. Is it cognizable? Is it non-cognizable? Is it bailable? Is it non-bailable? What is the sentence prescribed for that particular? Where is it tribal? Is it tribal by a magistrate or tribal by the Court of Sessions? So this will give you a broad outlook of what sort of offense are we going to deal with. Now, this brings you to the next stage, which is the drafting of the criminal appeal. And fortunately, in Rajasthan, we are very fortunate as high court lawyers or even as a district court lawyers when appeals come to us. For in Rajasthan, we have a good tradition that the complete record of the criminal trial is brought to us by our colleagues from the trial court, which is not the case, as I've noticed in the state of Karnataka while I was sitting there as a judge, or even in the state of Telangana. Many a times when I would ask my lawyers in Telangana High Court that please show me this document, they'll say, sir, this document is not available with us because it was never sent by our colleagues in the trial court. But here you will, in Rajasthan, you will have the benefit of a complete record before you. And it will be as voluminous, possibly as the entire record of the case coming from the trial court. Now, when you have that file before you, the question is, how are you going to go through that file? How are you going to analyze that file? What do you read the first thing in that file? My advice is that first begin with the FIRs. An FIR would be available readily as Exhibit P1, most likely either copy of the complaint or the formal FIR that is registered on the basis of that complaint would be as Exhibit P1 or P2, and that documents which have been handed over to you. The reason why I'm asking you to go through the FIR is because naturally it is the basis, the foundation of the entire prosecution case. The prosecution cannot differ from its FIR. It cannot travel too far from its FIR. Therefore, FIR gives you the bird's eye view of what the entire case of the prosecution would be. One of the points you will notice at the end is whether the prosecution begins to differ from its FIR. If it does, it is in trouble. If it goes contrary to or comes up with a totally different story, it is in trouble. Therefore, FIR is the first document you should read. And when you read an FIR, read it very closely. Don't just cursorily go through it for two reasons. Number one, the reading of the FIR would also tell you what are the possible arguments which can be raised. Therefore, first notice, and then as I'll tell you later on, how to analyze an FIR and how to make your notes from an FIR. Notice who is the complainant. Is it someone, a member of the victim, or is it as a police officer? Who has set the entire criminal machinery into motion? Number one. Number two, what is the place of the occurrence? What is the time of the occurrence? How far is the place of the occurrence from the police station? When the FIR is lodged, when did it reach the magistrate's court? Number two, who are the accused persons who are named? Are they named accused persons or unknown persons? Whether the FIR has been lodged against unknown person, because this will also help you while you're arguing your appeal. Therefore, also notice who are the named accused. Also notice what has been assigned to the accused, what weapons have been assigned, what roles have been assigned to the accused. Is it that accused is peripheral accused or is he the main accused? So analyze the FIR as much as you can. For your final argument before an appellate court would be that these are the ingredients which are prescribed by the law. These are the facts of the case as narrated by the prosecution. However, the facts do not fit into the ingredients of the crime. Therefore, my client is innocent. That's the ultimate argument that you will have to place. Therefore, FIR is a fundamental document. It's an essential document that you must have the details of the FIR on your fingertips. Next, read the entire judgment. Do not go at this point into the testimonies. First, read the judgment and then start analyzing the judgment and ask yourself the following questions. Number one, is it a case of direct evidence or is it a case of circumstantial evidence? Your preparation on both these counts will be quite different, as you will see later on. Therefore, ask your question, am I dealing with a case where there are indeed eyewitnesses? Or am I dealing with a case which is totally based on circumstances as there are no eyewitnesses? Or there are certain rare cases which begin as a direct evidence case because there are witnesses, end up being circumstantial case because the witnesses have not been believed, yet the conviction is on the basis of the circumstances. Therefore, first ask yourself this question, what sort of cases am I dealing with? Number two, How strong is the prosecution case against my client? And this is the crux of analysis. You will have to first read, when we are dealing with the prosecution case, what evidence out of the prosecution case has been read against your client. Therefore, look at the importance of the circumstantial evidence case. And especially in a circumstantial evidence, look at the evidence which was read. A, is it the evidence of last seen? B, is it the recovery from the accused? C, is the recovery corroborated by the FSL or the chemical report or by the postmortem report? How much corroboration is there? D, is there an extrajudicial confession? Is there a report which says, yes, the blood of the deceased was found on the clothes of the accused? Therefore, what are the circumstances which have been added as almost as links, number of links forming the chain? Then ask yourself, does the chain unerringly point to the guilt of the person, or there are missing links which make no sense, which may create sufficient doubt in the mind of the court to disbelieve the prosecution? Therefore, read your judgment very carefully. Also ask yourself question number 3. Has the prosecution brought in a believable or an unbelievable case before the court? And I'll give you 2 examples. We had one case, which is the case of Ankush Wadhwa, which was decided by a division bench of the Rajasthan High Court. It was quite a sensational case. I don't know whether many of you even remember that case. But it was a sensational case from Kota, where it was alleged that the accused had murdered his girlfriend, whom he had taken out for a ride. Apparently, they both had cold drink. There were allegations that he may have tried to mishandle her, physically exploit her, but she resisted and he killed her. So this was one strand, one story that the prosecution was bringing. However, when the case was being argued and the way the trial court had proceeded, it turns out from the record of the case, the prosecution did not come up with just one story, and that is the requirement of law, that prosecution must come up only with one story. It cannot give the judges 3 different options. But unfortunately, in that case, prosecution did not come with a single story. It came with 3 options. Option number 1, according to the testimony of the father and according to the FIR, the father said, my daughter has gone missing. She may have been taken to a hostel where she may have been gang raped and then murdered. That was the gist of the FIR. Therefore, now you have a story of a gang rape and a possible murder, or a possible gang rape and a known murder. Story number 2, and these were prosecution witnesses produced by the prosecution who said, we don't know anything about the young lady, but all we know is that Ankush Wadhwa met with a car accident. He was lying in the car. He was semi-conscious. When we asked him what happened, he said, my car has struck and there's an accident. I need a glass of water. Can somebody please get me a glass of water? Therefore, there was a question of an accident, possible death of the young lady through an accident and not even through a murder. Then there was a third version, and the version was that the CBI introduced a witness who was the younger sister of the deceased, who says, no, I saw Ankush Wadhwa take my elder sister with him in the evening from the temple. After that, my sister never came back. And the police version that actually it was a case of murder. Now, when you come up with 3 unbelievable stories, naturally you have no other option as a judge but to give the benefit of doubt to the accused. And this is exactly what the High Court of Rajasthan did. Another case which I had dealt with in Telangana was a case based on a testimony of a sole eyewitness. And as all of you will know, that sole eyewitness has to be a witness of sterling worth. the slightest doubt in the case of the prosecution should be thrown out. At the first blush, it appeared to be a very strong case because here was the sole eyewitness who was the son of the deceased. And what he says in his testimony is that the accused was repeatedly going through our farmland. Repeatedly, my father told him to stop going through our farmland. In the morning, he trespassed into our farmland. My father tried to stop. In the evening, when he came with his tractor, again, my father tried to stop him, and the accused got mad and he hit my father with the tractor and killed him. And I am the sole eyewitness. After this alleged murder, the other farmers who were near about, they all came and they rushed after they heard my hue and cry. And that is how my father died. Certainly on the face of it, it looks like a solid case from the side of the prosecution because there is only the sole eyewitness. The question before us was, is this sole eyewitness a believable witness, or are there certain cracks in the armor of the prosecution which tell us that no, prosecution is not coming with clean hands? This story is certainly unbelievable. And when we started analyzing the case during the course of hearing, we discovered that according to the site plan, the dead body was not in his farm as claimed by the sole eyewitness, that you'll find the dead body in our farm. In fact, according to the site plan, the dead body was lying on a kacha road adjacent to the farm. Number two, the IO says, according to the sole eyewitness, the alleged murder had taken place at 6 o'clock in the evening. On the other hand, the IO says that at 9 o'clock in the morning, the next day when I went, I found the dead body lying on that kacha road. Now, what struck both of us in the division bench, both the judges, myself and my colleague, that the occurrence is said to be of the evening at 6 o'clock. The sun is there, the villagers come. Would they leave the dead body entire night in a village in a kacha road? Or would the first human contact would have been, a normal human contact would be to pick up that dead body from there and rush it either to the nearest hospital, hoping to save the person, or if they're convinced that the person has actually expired, to carry the dead body back home. Why is the dead body lying on a kacha road throughout the night? And that too, when there's a possibility that the body may be attacked by wild animals, by village dogs. The witness does not say, the sole witness does not say that I stayed with the dead body the entire night. Now, these are the cracks which developed in the case of the prosecution. Therefore, we concluded the prosecution is coming with a story which is unbelievable. And hence, again, the benefit of doubt goes to the accused. Then ask yourself also, is the prosecution hiding material facts or material witnesses from the court? Because now you're about to analyze the judgment and looking at the prosecution, you have sufficient amount of information as to what prosecution is pleading, what it is trying to, sort of evidence it has brought forth while going through the judgment. So ask yourself, is the prosecution hiding anything? For example, if there are injury marks on the accused, is there an explanation or no explanation, especially if those injuries are of serious nature, not of minor nature, but if they're of serious nature. Now, suppose the accused has an injury on his head or a stab injury on his body. Are these injuries being explained by the prosecution? If not, that throws a grave doubt on the case of the prosecution. It may even throw a grave doubt on what we term as the genesis, the beginning of the prosecution case. Moreover, is the prosecution hiding material documents? For example, suppose there is an FSL report, or suppose there's a DNA report. However, the DNA and FSL report is never produced. Take an example that the recovery memo is not produced. There is an identification parade, but the identification memo is not produced. Then naturally, under Section 114 of the Evidence Act, the court should be requested to draw adverse inference against the prosecution. Moreover, suppose the prosecution is not producing the material witness, then why is it hiding the material witness? We'll tell you exactly what happened. Again, an adverse inference to be drawn against the prosecution. So ask yourself, is the prosecution coming up with clean hands or unclean hands? The moment you find that it is coming up with unclean hands, that will make your job a lot easier. Dealing with cases where there are more than one person, ask yourself the question, are innocent people being roped in? Generally, in a case of 149 IPC, innocent people are roped in. Generally, in a case of 304B, innocent people belonging to the family of the husband are roped in. So ask yourself, are innocent people being roped in, or is it that it's a natural narration of the events and only those who are relevant as offenders are being mentioned by the prosecution? Number 7, ask yourself how much corroboration there is against the case of the prosecution. Unfortunately, what happens is, in a crashing hurry to convict a person, the learned trial courts tend to look at the oral evidence. And they say, yes, PW number 128 has said so, therefore conviction recorded. However, the learned trial court does not look at how much corroboration there is of the witnesses. And that is where you will find the biggest crack in the armor of the prosecution. So ask yourself, what is the corroborative evidence? For example, you may have a recovery witness who says, yes, the accused took us there, he got this knife recovered from there, the knife does have blood on it. And that's where he stops. And that's where he is expected to stop. Now, the trial court says, yes, the weapon of offense recovered at the behest of the accused, therefore he is guilty. But ask yourself and ask the court, where's the FSL report on it? Where's the report saying that the blood belongs to the deceased? Because it is the fundamental duty of the prosecution not only to show that a blood-stained knife is recovered, it is more so their duty to prove the fact that the blood belongs to the deceased does not belong to any other person, nor to the accused. Otherwise, how do we know, in sitting in the court, that it is not blood belonging to a chicken or to a goat? How do we know it's human blood? Therefore, the corroborative evidence is necessary to read that recovery. If the prosecution stops at the point of saying there was a recovery, human blood is discovered, even that is insufficient to convict a person on the basis of that recovery. Therefore, ask yourself, what sort of corroboration is there? In cases of direct evidence, check up. Are the testimonies of the witnesses corroborated by the site plan? Because many times you will find there's a clear-cut contradiction between what they have narrated and what the site plan tells us. And please remember, one of the fundamental principles in criminal law is men may lie, circumstances, documents do not. And especially those documents which are contemporaneously made with during the investigation. Therefore, the inquest report, the site plan, the recovery memo, the identification parade, the injury report, the post-mortem report, they become relevant to see whether there is corroboration or not. And that is what is going to help you separate the wheat from the chaff. And that is what is going to ultimately help the judge from deciding whether the person is guilty or he's framed, but he's an innocent person. Then also ask yourself what is the defense taken by the accused? Because you are, after all, the defense counsel. So you cannot go against the defense taken before the lower court. However, there are certain defenses, for example, the right of private defense. The Honorable Supreme Court has said in a number of cases, even if this defense is not pleaded by the defense counsel during the trial, but if the court comes to the conclusion that yes, it is the right of private defense which was exercised, the benefit of such defense must be given to the accused, although never pleaded during the trial. So please remember and ask yourself, is it a case of total denial? Is it a case of silence? Are you pleading any of the general exceptions given in the chapter an IPC on general exceptions. Are you pleading a specific exception even to murder? There are certain exceptions that will reduce it to culpable homicide, not amounting to murder. What is your defense before the trial court? Then also very carefully read the arguments of the defense counsel before the trial court, because that is going to be the skeleton of your appeal. Now, once you have analyzed the judgment so thoroughly, the skeleton and the muscles of your appeal are ready in your mind. Therefore, now the question is, how do I draft my appeal? There are two schools of thoughts on this. One school of thought says that the criminal appeal should be done in very vague terms and general terms and should not be full of specific information. I, as a judge, disagree, and I'll tell you the reason why I disagree with this thought. As a judge, when I read a file, I would like to know not only the gist of the case of the prosecution, I would like to know what is the case of the defense and what are the points that it is going to raise tomorrow morning when the matter is going to be argued. What are the loopholes that it's going to point out? Therefore, I would like to see that in the appeal itself. Therefore, I prefer to have a rather detailed, and in fact, I think most of us judges would prefer to have a rather detailed criminal appeal placed before us. So at least we have some information, some impression of what is going to be argued and which way the case is likely to tilt. It is not to say that when we read the files, we make up our minds. We do not. A good judge never would. He will still step into the court hall with an open mind, ready to listen to all your arguments. But while you're drafting the appeal, keep these points in mind. Number one, emphasize the contradictions, especially between the witnesses or between the witness and the documents, or even between documents. For example, you could have a case where the inquest report says there is no injury visible on the body. And yet, postmortem report says there are 52 injuries on the body. Now, how could that be? When the body was discovered at the scene of the crime, there were no injuries. And yet, in postmortem 2 report, it says that there are 52 injuries. Therefore, ask yourself, are the documents contradicting each other? Therefore, analyze and emphasize the contradictions, because you are now trying to do in your appeal is to tear apart the case of the prosecution, or at least create sufficient doubt in the mind of the judge and the mind of the court that the prosecution case cannot be accepted as the gospel truth. And these are the reasons that you must state in your appeal. Then also emphasize on the documentary evidence, the postmortem report, the FSL report, the chemical report in cases, especially in case of NDPS, ballistic report. Find out how many arguments you can come up with through the postmortem report. And that is why it is imperative that all of you must read beyond criminal law, other areas of law. For example, you must read medical jurisprudence, you must read ballistics, you must read about poison. How many different types of poisons are there? Are the poisons organic, inorganic, vegetable poisons, chemical poisons? What is the effect of a poison? What are the symptoms of a poison? How long does it take a person to die? In cybercrime, you must know what a computer is. How is the message transferred over a computer? How does an internet actually work? What is identity theft? So you must read beyond just IPC, CRPC, and evidence. Criminal law is no longer confined to these things. It deals with other aspects as well. You must read about psychology, because that will also help you analyze and deal with a witness. Not to mention that it will certainly help you deal with a judge. What sort of psychology of the judge am I facing? So you must acquaint yourself with these other areas. Then emphasize in your appeal the quality of the witness. Is he an interested witness? Is he a hostile witness? Is he a child witness? Is he a stock witness? Is he a chance witness? What sort of witness has the prosecution brought forth? Then come the most important part of your appeal, the grounds of appeal. And it's very simple. We tend to think that it's very complicated, but I'll tell you the secret of how to make it simplified. or to simplify the procedure. Take your annual SCC manual that you get, the annual volume of SCC. Go to the topic index, open the topic index. If you go through the topic index, there's a complete topic called criminal trial. And every criminal lawyer must have this photostat copy of this on his table, and especially the young ones. For in that topic index under criminal trial are given all the grounds, possible grounds, which can be raised in a criminal appeal. For example, you're dealing with a case of rape, and especially a case where the prosecutrix happens to be, let's say, just about to be a major, 17 and a half. Therefore, the age will become very imperative. And in rape cases, age always is, because if she is on a borderline case, you're trying to argue that no, actually she's an adult, therefore it's a case of consent, not of rape. Beginning with the topic age, that index will give you all the other grounds, and sometimes such unusual grounds, such as identification of a person through his voice. Now this comes in handy if you're dealing with a murder case where the murder had taken place at the dead of the night, and yet the prosecution is trying to say, well, the person was identified by the witnesses by his voice. Can a person really be identified by his voice? Or even such rare topics as moonlight, murder under moonlight. How reliable is a moonlight to identify a person? So you will get all sorts of, from very general defenses to very specific to very bizarre defenses. And it's all available and mentioned in that topic index. So please study the topic index carefully. It will talk about weapons. It will talk about other circumstances, death by poisoning. What is the duty of the prosecution when you're dealing with a case where murder has occurred, death by poisoning. So it's all available there. So keep that in mind and keep that in front when you're drafting and dictating your appeals. And believe me, in criminal appeal, as in writ petitions, there are only limited grounds that we can come forth. There are not more than 12 grounds in any criminal appeal. So it always rotates and revolves around the same set of grounds. And once you're prepared one murder appeal thoroughly, you will be ready to argue and prepare your next murder appeal, you know, with a lot of sense of ease. Now, how does one prepare an appeal? That is the most important part, because unless your preparation is very well done, you will not be able to present a case. And please remember, in a criminal appeal, you're the master of the facts, and most criminal appeals revolve only on facts. They don't really generally revolve around interpretation of law. It's a rarity that you will get a criminal appeal where the interpretation of law will become relevant. But basically, it's a case based on facts. The first thing I would do as a criminal lawyer is to buy myself thin notebooks. And I'll tell you why I'm asking you to buy notebooks, because this is how you're going to prepare your criminal appeal. And this is the gist of my entire lecture. You have to deal with the facts. And the reason why I'm asking you to thoroughly, critically analyze the evidence is very simple. If you look at the rate of conviction in our country, 48.8% of the cases end up in conviction. That means still almost 51% of cases end up in acquittal. That means majority of our cases are still ending up in acquittal. In fact, you will find that the more you analyze an evidence, the more you go through the file, the more you will be convinced that it's a case of acquittal and not of conviction. 80% of the prosecution cases are so weak because the investigation is done extremely poorly. The prosecution has not presented its case properly. Therefore, go with the confidence that you are going to win the case, not lose the case. It's a rarity to come across cases where the prosecution has come up with a watertight case. Now, when you have this notebook, turn to page 1 and again go back to the FIR. As I said, critically analyze the FIR and jot down everything from that FIR. The name of the complainant, place of occurrence, time of occurrence, all that we had said earlier. Put that in page 1. Page 2, come up with a complete list of witnesses, which is readily available in any criminal file. That will be readily available even in the record that you have already have. Page 3, write the list of documents that the prosecution relies upon, and I'll tell you why I'm asking you to write all these things. Once you do that, then also write the list of page 4, right? The list of defense witnesses, because you're going to emphasize on the defense witnesses. Also write down if there are any documents or any material, articles produced by the defense. Then begins the critical analysis of the testimonies. And this is where you have to really slog. And it's a time-consuming exercise, but this is what will make you a great criminal lawyer and will distinguish you from a good and a great criminal lawyer to an ordinary criminal lawyer. Begin jotting down with the examination in chief of each witness, jotting down each sentence of his testimony, no matter how long that testimony may be. But before you jot down, just do yourself a favor, fold the left side of the page, leave 2 inches and fold it there after 2 inches. And I'll deal with why I'm asking you to leave that as blank space on each page. Jot down each one of his line, and under the line, write down the line number, the page number, the paragraph number. Please also note whether it is from top of the page or bottom of the page. And I'll tell you, we'll deal with it when we talk about your argument in the court, why this information is critical. Do that with all the witnesses from PW1 to, let's say, PW8, if there are only 8 prosecution witnesses. Having done that, go on to the defense witness, if any, do the same thing with them. Now you have the gist of the entire talk record with you, and now begins the analysis. And this is where the left-hand side will now come into prominence. Start reading each witness, and lo and behold, you will start noticing the contradictions between the testimonies, the omissions in the testimonies, the exaggerations in the testimonies. You will start seeing the contradiction between a witness and the document, and start noting down all these contradictions. For example, PW1 says that PW3 made the following statement at the scene of the crime. PW3 is absolutely silent. That he made there's no evidence in his testimony saying he made any statement. PW2 tells the court that PW5 came to my house and said, your father has been killed, therefore I rushed to the scene of the crime. PW5 is absolutely silent that he ever went to the house of PW2 to tell him that your father has been killed. And that is what prompted PW2 to rush to the scene of the crime. Start jotting down all these contradictions on that left space that you had left out. Because when you present a testimony, let's say I'm analyzing, I say, yes, during my argument, I said the star witness, PW8. So I read out the testimony and then I tell the judges, he is the star witness. Now kindly consider the contradictions in his testimonies. Now kindly see what he is doing. Is he a reliable witness? Suppose it's a recovery witness, but he happens to be a chance witness. Suppose he is a recovery witness and I can prove through his testimony that he is a stock witness. He has not only helped the police in one case, he has been their recovery witness in 20 more. In the famous case of Vaman Narayan Ghia, this is one of the points that bothered us while we were hearing the appeal. The recovery witness was a recovery witness for the police in 60 other cases. Rather surprising that the police keeps on finding the same recovery witness. Every time there's a recovery, they just locate one person in a large city called Jaipur. And they go and grab that person and say, now become our recovery witness. What sort of recovery witness do you have? Therefore, start writing all the contradictions on that left-hand side. Do the same thing with the documents also. Note whether the documents have any contradictions between them. But do not note the minor omissions. Many times, especially the young lawyers, when they argue in the court, they say, sir, one witness said it was 10:30, the other witness said 11 o'clock. Honorable Supreme Court says, forget about it. Mathematical precisions cannot be had from witnesses. As far as the witness say that yes, the occurrence occurred at the daytime, in the morning, that is sufficient. Yes, the great contradiction would be if somebody says the offense occurred in broad daylight and another witness says, no, it occurred at the dead of the night. But the difference between 10:30 and 11, that's a minor contradiction. So please do not emphasize on that. And let me tell you one thing that irritates the judges, if somebody keeps on emphasizing only on minor contradiction rather than showing the major contradiction. Then also write in your notebook the character and kind of witness. For example, if he is a hostile witness, in that index you have made of witnesses, write down hostile. So you'll know how many witnesses have turned hostile during the course of the trial. Write down whether he's a recovery witness, whether he's an interested witness, whether he's a child witness. So that should be available, readily available in your index itself. And this will help you while you're arguing your case. Also ask yourself and jot down whether the witness happens to be a fake witness. For example, in circumstantial evidence cases, what happens is in order to strengthen the prosecution case, prosecution will always come up with this story, oh, well, there was an extrajudicial confession made. So now you have a fake witness being implanted into by the investigating agency, will come and say, yes, yes, that man came and made an extrajudicial confession to me. Ask yourself, does it pass the 3 tests for acceptance of an extrajudicial confession? A, is it natural? B, is it made to a person in whom the offender would have an implicit faith, whether he is his relative, whether he's a dear friend of his? Why does this offender go to this person to make a confession, and that to an extrajudicial confession? Now, in one of the cases in Telangana, this is exactly what happened. The entire prosecution rested only on the basis of extrajudicial confession. And the extrajudicial confession, surprisingly, was made to a person sitting at 4:30 in his office by the accused. The accused happened to merely walk into his office and said, by the way, I want to make an extrajudicial confession, and let me tell you, I murdered so-and-so. The question is it natural for someone to enter into a bureaucratic office and tap the person sitting at the desk and say, sir, I like to make an extrajudicial confession? That person is neither his relative, nor a friend, nor anyone close to him. He's a total stranger. And this is what the witness admitted in his cross-examination, that this man was a total stranger who walked into my office. Now that cross-examination demolishes the entire case of the prosecution. And that is the reason why the offender was finally acquitted by us. Then also emphasize and note down in your notebook the logic of the trial court. Because this is the ultimate frontal attack of yours will be on the logic of the trial court judgment. Therefore, ask yourself, has the learned trial court judge looked at the relevant evidence? Has he interpreted or misinterpreted this evidence? Whether he has ignored relevant evidence, whether he has admitted inadmissible evidence. For example, in Telangana, unfortunately, most of my judicial officers have this uncanny habit of reading the confession made to a police at a police station as a substantial piece of evidence. Therefore, that interrogation record is read as a substantive piece of evidence, which is prohibited by the Evidence Act. But unfortunately, the judicial officers of Telangana did not know that till I started asking them, On what basis are you reading this evidence, sir? It's inadmissible except under Section 27 of the Evidence Act. That is a very limited part of his statement given to the police. That part which will lead to the discovery of a fact can be read, nothing else. Therefore, stop reading the interrogation part of his statement when he said to the police, well, this is how I killed him. That cannot be read. Therefore, please ask yourself and emphasize in your notebook whether an inadequate piece of evidence has been brought in. Or ask yourself, is the entire case decided on the basis of conjectures and surmises? And there are possibilities that many of our judicial officers have started doing that. And it's unfortunately, but it's happening, where judicial officers just reproduce the testimonies of the witnesses and record the conviction without analyzing the evidence. So then point out that the entire case is A, without any reasoning, B, based on conjecture and surmises, which cannot be because the burden of proof and the extent of proof is beyond a shadow of doubt. Therefore, conjecture and surmises have no play in a criminal trial or in a criminal judgment. Then ask yourself what cogent evidence has been read against you, because you will be asked this question. What is the evidence that was read against you? So jot that down on a piece of paper in that notebook. And that is how you will now begin your opening of the case. Now the presentation of the appeal. Let me now deal first with the art of advocacy, because that is the most crucial thing that any lawyer must know. And these are the things that the judges do look for, although you do not realize this is how the judge's mind works. The first thing we look for in a counsel is something which may appear very irrelevant to you, but it becomes extremely crucial to us: your appearance in the court. How well dressed are you? How well groomed are you? Your etiquettes, your mannerism. Someone who comes to the court shabbily dressed clearly shows that he has no interest in his own self, let alone in the interest of his client. Someone who does not exude confidence, positivity, is not likely to get a favorable order from the court. Therefore, groom yourself. Make yourself presentable. Go absolutely clean shaven before the court. Don't look like someone who just rolled out of the bed and came to the court. That is the most irritating thing to any judge, because when we judges go to the court, we groom ourselves. We spend time looking at ourselves. We want to give a certain impression to the public at large that now you have really entered the temple of justice. Therefore, those who are the priests of this temple, namely the lawyers, cannot afford to look like, they've just rolled out of the bed. Secondly, we look at the reputation of a lawyer. Your reputation, in fact, precedes you. Even before you come to the dais, we already know your reputation. Your reputation precedes you in the sense that as lawyers tend to dissect judges, we judges also love to dissect all of you. And you are ruthlessly dissected in our common room when we meet for lunch. If you're a lawyer who is known for preparing his cases very well, who is known for keeping himself within the record, who is known for his mannerism, his etiquettes, his brilliance, his logical arguments, we applaud that lawyer in the common room. If you're a lawyer who is cantankerous, who is always foul-mouthed, tends to shout in the court, we know that even before you have approached the dais, that we have a headache coming our way. Therefore, please safeguard your reputation. We know what your reputation outside the court is. We certainly know what your reputation inside the court is. The biggest weapon of a lawyer is his politeness. And if you observe any of the senior counsels, whether of your own Honorable High Court or of the Honorable Supreme Court, what will impress you is their politeness. Please go through the way and see how Mr. Fali Nariman used to appear or appears before the court. Even how the learned senior advocates in your own high court appear before the court, you'll find one common denominator. They have an utter sense of politeness. We as judges many a times realize, and we are well aware of the fact that some of these senior advocates are far more brilliant than we are. They're specialists of their area. We may not be. And yet when they address us, they do it with all sense of humility at their command. Even when a judge may ask a question that may sound rather ridiculous, they will never tell a judge that it's ridiculous. They will simply say that, Your Lordship, I asked myself this question, which is a very polite way of reminding the judge that it's an impertinent question, or a question that should not really have been asked in the circumstances of the case. But he would never say that to a judge, that I'm sorry, Your Lordship, you have failed to appreciate my arguments, or you're off the record. That never should be. Please remember the relationship between the court and the lawyer is that of the king and the courtier. The courtier can never afford to irritate the king. You irritate the king and you're out of that court, or you will have your head taken off in the olden days, in the feudal days. If you irritate a judge by whatever means, you will not have a favorable order. Therefore, politeness is one quality that must be ingrained. The other thing we look for in a lawyer is intellectual honesty. There are certain judgments which will go against you. There are certain circumstances which will go against you. You must be able to tackle that. You must be able to tell the judge that I will now distinguish these judgments which are apparently against me, but now I will distinguish and show Your Lordship how they are inapplicable to the present case. Therefore, we want to see intellectual honesty. If there are indeed judgments which are against you, you should be frank enough to say, yes, they are indeed against me. And then want to persuade His Lordship to take different view. The other thing that we look for is patience of the lawyer towards the judges. Of course, each judge and every judge must be patient towards the learned members of the bar. But then the question is, how patient are you towards us? You have to realize we too are human beings. We do come at times, we do come to the court with a head full of troubles, of certain concerns, which may be personal, which may be family, which may be community, which may be some news item which has upset us. There are moments when we do get tired, especially at the end of the day. And the question is, how patient is the judge being with how patient is the lawyer being with the bench? There are times when we give hints, the lawyer refuses to take it. Perhaps when a hint is given, it should be immediately be picked up by the lawyer and then move on. If the judge is saying that I am not convinced, Mr. Counsel, by your arguments, argument number 3, there's no point of repeating that argument 5 times. Simply bow down to His Lordship and say, as Your Lordship pleases, let me take Your Lordship now to my 4th argument, 5th argument, 6th argument. Hopefully 1 or 2 arguments will convince their Lordship to pass an order in your favor or pass the judgment in your favor. The other thing we notice is how well do you know your judges? And to know your judges never ever means to know them personally. Oh, good Lord, judges and lawyers should keep themselves as far away as possible. To know the judges, to know the psychology of the judge. Is the judge very liberal or is he conservative? Is he very technical? Is he skeptical? Is he cynical? Does he have certain weaknesses? For example, there are judges who are known as pro-labor, anti-labor, pro-management. There are judges who are known for their sensitivity towards gender issues, where they're inclined to tilt more towards women who may be involved. There are judges who like to be taken into the depth of the matter. There are judges who like to be kept only at the periphery of the matter. The moment you start taking them into the depth of the matter, you lost your judge. Therefore, know your judges. What sort of judge am I dealing with today? And accordingly, modify your arguments. The other thing, as I said, we look for the vast knowledge you carry with yourself, not only about your life, experiences of life, but about knowledge. And as I said, read as much as possible, because law, interestingly, is the only subject amongst the human beings that covers all the other subjects of human knowledge. There's not a single part of human knowledge that law does not cover. Even outer space laws covers the outer space. A satellite is falling from the outer space, falls on Bombay. Whom do we sue? Suppose 4 lakh people die. Whom do we sue? What is the forum? Where do we sue? What is the argument? What are the treaties? What are the laws on outer space? Therefore, broaden your reading habits. Read as much as you can, whatever you can. Immaterial. You may think that today this topic is absolutely irrelevant. Why am I reading this? Read it. Someday case will come to you where that topic will become highly relevant. To the men lawyers, I say, please even read women magazine, womanly magazines. For example, read Sakhi, read Sarita. Now you may ask, why is the judge asking me to read the womanly magazine? Because it is these magazines that tell us about the point of view of women. How is it that women are looking at this issue? Take the example of triple talaq. When you started reading the magazines, there were so many women from the Muslim community who started criticizing triple talaq, saying, no, it's ruining our lives. That was a strong point of view. Therefore, know what is the concern of the women. They can't be ignored. They are 50% of our population. And there's so many gender issues which are arising. In domestic violence cases, you will have gender issues. Is a working woman, does she have the right to pay more attention to her professional work than to the health of her child? Would we still want her to stay back when she has an important meeting to attend to in her office? Now, what happens to rights of the women? What happens to their interest? And as we go along as a nation, more and more gender issues are going to arise. So therefore, please consider, read, what is the point of view of the women? We must be gender sensitive. And in today's day and age, we cannot carry on our feudal mentality or patriarchal thinking about women. Those days are gone and over with. You see that every day when you're dealing with your daughters, when you're dealing with your sisters, when you're dealing with your daughter-in-laws, with your mothers, they are no longer what they used to be in the generation of our grandmothers. My mother, when she got married, she had 13 veils on her face. Today, if my daughter gets married, I doubt it if she would have any veil on her face. She will go like a modern bride. Therefore, we cannot expect our women to be classified, to be structured the way they were. Therefore, one of my things is that please read as much about women's concern. For example, do you know that there is scientific evidence to show that when a woman is pregnant, and especially after post-delivery, she does go through a depression. There are women known to have killed their children during post-delivery depression. Now, unless you read about post-delivery depression, because please remember, a woman's body undergoes a tremendous chemical changes during pregnancy and post-pregnancy. During pregnancy, women have certain nature, certain behavioral patterns, not because of who they are, but because of the chemical changes which are taking beyond their control. They're taking place, they can't help it. Imagine, and we men can never imagine this, but imagine your body turning your blood into milk. What tremendous chemical changes must be happening in the body to turn my blood into my milk, a milk which is not only going to feed my child to be, but is going to protect my child by giving it antibiotics. That's the only way a child gets his antibiotics from the milk of the mother. That's why breastfeeding is so emphasized in every culture. So we as men cannot realize that. That's why I'm saying, please read all these things to equip yourself, both to learn about life as well as to show your knowledge in the court of law when these questions are raised before you. One thing that we judges do not like is emotionalism. And this is why I take you back to what Aristotle said: no emotions in the court. Therefore, do not attack an opponent's counsel. Please confine yourself to the facts of the case, not about who is your opponent counsel. Do not exaggerate. Do not end up giving long speeches, because you're not standing in a political arena. You're not standing at a crossroad out in the public to give a long speech. Do not moralize. Many of the lawyers have a tendency that we seem to blur the distinction between morality and law. Something may be morally incorrect. Does not mean it is legally illegal. No. Therefore, do not bring morality into the court. Yes, but at the same time, know where you can get sympathies of the judge, but do not over-exaggerate it. First, know your judge. Is he one who does show sympathy towards the people, or he does not? There are many judges who are so objective. They don't care whether the victim is a woman, was a widow, was illiterate, was a villager. It hardly bothers them. There are other judges who would be swayed by these facts that, oh, it's a widow who is involved. Therefore, by knowing your judges, you would know what fact to emphasize before the judge. But the less the emotionalism in the court, the better it is. Now, about arguing a criminal appeal. First, we have to know what is the difference between arguing a civil case and a criminal case. And mind you, they're diametrically opposed to each other. In a civil case, what you're arguing is that these are my rights. These are the duties of the respondent. The respondent has failed or committed a breach of his duty towards me. Therefore, my right has been violated. Hence, I'm entitled to receive such and such compensation, or a decree for a specific performance, or a relief. For example, if you are the landlord arguing a case of eviction of a tenant, then say, I am entitled to relief of being restored the possession of my rented property to this defendant tenant. Therefore, it is a positive argument. However, in a criminal trial, your argument is totally negative. What you are arguing in a criminal trial is that these are the ingredients defined by law in such and such provision. So that is in one bucket, one class. The second class are the facts of the case. And your negative argument is that the facts of the case do not fulfill the ingredients of the crime defined by law. Since they do not fulfill and they cannot be brought within the ingredients of the offense, my client is innocent. It's a negative argument. Look at the argument in a writ petition. In writ petition, you're again going for a positive argument. These are my statutory rights or fundamental rights, which have been violated by the state. Therefore, please restore my fundamental right or prevent the breach of my fundamental right or of my statutory right and give me a positive order in my favor. It's a positive argument. It is not a negative argument. Therefore, first you must understand the type of argument which are needed to be placed before you talk about how you're going to present your argument. Now, how does one begin the opening of a case? The opening of a case in a criminal appeal is very simple. Step number one, read the FIR. or begin by saying that my client has been convicted for offense under such and such, such and such sections of IPC or whichever statute you're dealing with, NDPS, SCST, whatever. Then read the FIR. Analyze the FIR for the judge, and then talk about step number 2, what evidence has been read against your client. Many times what the mistake most defense counsel do is, they will begin with making a statement, your lordship, my client is innocent. Well, if your client were so innocent, then what is he doing in a conviction? How was a conviction recorded? If you were so innocent, then what are you doing here? Therefore, first tell the judge not that your client is innocent or guilty, because that is an ultimate conclusion, not to be drawn by a lawyer, but to be drawn by a court. Therefore, but say, now these are the following evidence read against my client by the learned trial court. And please emphasize this, especially in a case of circumstantial evidence. Because in circumstantial evidence, naturally, even the judges are dying to know, okay, what were the circumstances which were stacked against you and were read against you? So quickly take the court, say, these are the 5 circumstances which have been read. Circumstance number 1, last seen. Circumstance number 2, recovery. Circumstance number 3, extrajudicial confession. Circumstance number 4, identification, or whatever you may have that is stacked against you. Therefore, give the gist of the case of the prosecution and the logic of the trial court before the appellate court. Now begins your actual argument. Number 3, step number 3. Give a summary of your argument saying, sir, these are the 5 or 8 points I'm going to raise to break through the case of the prosecution, and just summarize it then and there. This has 2 advantages. Number 1, the judges know exactly what is the scope and ambit of your complete argument. Number 2, if the judges have already read the judgment, suppose they already agree with first three of your points, they'll tell you very frankly, Mr. Counsel, forget the first 3 points. We already agree on those. Come to point number 4. We disagree on your point number 4. Okay, that will save you the time, save the valuable time of the court, will be less taxing on the judges as well as less taxing on you. That will reduce the scope of your arguments. Then go directly to point number 4. Take your points one by one, elaborate them, and now go back to that notebook. In fact, you need not even have your file before you. And now begin talking about the evidence, the prosecution evidence, PW1, contradiction, omission, exaggeration, contradiction with this. Now go one by one. And when you're reading that evidence, now go to your notebook and say, line number 8, para number 2 of line number 8. And line number 8 from the bottom of the page, your lordship, not from the top of the page. Once you argue in that manner, the judges are absolutely convinced that you have come thoroughly prepared with your case. They see you not arguing from a file, but from a notebook. And tell them page number what of that record. If exhibit P8 is on page number so-and-so, refer to them. Postmortem report, exhibit P8, page number 92 of the paper book. And that is why I was asking you to write line number, para number, whether it is from the top or from the bottom. Take them through your argument one by one. At the end of each argument, support your argument with the case law. Say, okay, on identification, one of the usual defense which we used to have was identification for the first time in the court is no identification at all. This was one of the defenses which were available to a defense counsel in the olden days. If you have to argue that, then say that the Honorable Supreme Court in such and such judgment has held this. So you're buttressing each of your argument at the end, and that gives the learned judges sufficient material, A, to dictate their judgment, B, to simplify it for them. And while your argument, you would always notice, invariably judges take copious notes. So they are noting down your judgments also. So bring them through the case law. But before you can bring them through case law, also know what is the rule of precedent. Do not cite a judgment before a division bench, a judgment delivered by a learned single judge. Similarly, if you're going to cite a judgment of another high court, make sure it's a full bench decision, not that of a division bench or a single bench. Because every high court is bound by either A, the judgment of the Honorable Supreme Court, or B, by its own judgments. But we are not bound by any judgment of any other high court. It may have a persuasive value, but it will have a persuasive value only if it is a judgment of a full bench. Similarly, also, you need not bring 10 different judgments of the Supreme Court on the same point. All you have to do is say the landmark judgment is this, and the last judgment in which it has been followed is this. So therefore, for each point, you have to only show 2 judgments at best. Otherwise, just rely on the landmark judgments. It is the landmark judgment which has been followed subsequently, repeatedly by the Honorable Supreme Court and certainly by the rest of the high courts. So you must know the rules of precedent. Do not ever cite a judgment which has been overruled. In SCC, the soft copy of SCC, the CD that we, or the key that is available, SCC will tell you even in which point a judgment has been overruled, because it's not necessary that a judgment has been overruled on all the points decided by it. It could be that 1 or 2 points have been overruled subsequently. So the SCC will clearly indicate that for you. So please make sure that you do not cite an overruled judgment. Next point of argument will be naturally the weakness of the prosecution case, and most importantly, the logic of the trial court, whether it is giving a consistent logical flow to its argument or not, or whether it is based on conjectures and surmises. Suppose you are not appearing from the side of the accused, but now coming from the side of the victim or the complainant, then what happens? Then how would you argue your case? Because naturally, you're not going to have a negative argument. You're not going to say, sir, it doesn't, the facts don't fit the ingredients. Now, suddenly your arguments change. Of course, your preparation would be the same, but there are 2 or 3 points that you will first have to argue. First of all, the facts do fit into the ingredients of the offense defined by law. Therefore, he is guilty and nothing but guilty. Number 2, since the cardinal principle while we deal with a judgment of acquittal is that the scope of interference in an appeal arising from an acquittal order, the scope is very limited. In case there are 2 interpretations of an evidence and a view has been taken by the trial court, which is a reasonable view, invariably the appellate court will not interfere. Therefore, your second set of argument would be that given the evidence, there cannot be 2 possible views. There can only be 1 view. And the view that is being stated by me is the correct view. The view taken by the learned trial court is the incorrect view. Therefore, you would have to convince the judges that there's no 2 possibilities of interpretation. There's a single interpretation. Hence, you would have to emphasize A, on the strength of the prosecution case, on the weakness of the reasoning of the learned trial court, that it has overlooked relevant evidence, it has misinterpreted relevant evidence. So those are the points. Again, it is going to be an argument on the positive side, not on the negative side. So you'll have to change your strategy as a counsel. Suppose you come across a case which the prosecution has a watertight case against you, then what do you do? And there are cases in murder appeals where the prosecution is watertight case. Now their options are twofold. Number 1, you could argue that it is not a case of murder, but it is a case of 304 part 1 or part 2. You could emphasize that it comes under one of the exceptions under section 300. Or the second option is that you could say that the offense may have been committed, but the sentence that was pronounced is too heavy a sentence. It's shockingly disproportionate. Therefore, sentence needs to be reduced, and preferably the sentence undergone by the accused is sufficient for the just punishment of that person. Therefore, you are no longer arguing about the conviction, but your argument is about reduction of sentence. This comes in also handy when you're arguing a death reference. Death reference cases invariably are that the prosecution has come with a very strong case. Now, the question there is not whether a series of murders were committed or not. The question there is of sentence, whether he deserves to be hanged till death or he deserves to be given life imprisonment. Therefore, naturally, your ultimate argument is that please reduce the death sentence to life imprisonment. Or a third option now given by the Honorable Supreme Court, that please reduce it to 20 years. Because that is one of the things that naturally the prosecution will go on harping that no, continued the death penalty. But your other option is that please reduce it to 20 years or even make it till the end of his life, but do not hang him. So these are the ways and the means. Lastly, when you end your argument, please summarize your arguments once more, because this will simplify the things for the judges when they're about to dictate the judgment. So always end your arguments with a summary of all your arguments. Repeat what the 8 points you had mentioned earlier. That, sir, these are the 8 points that I had raised, which I have elaborately argued before your lordship. Last thing, how do you tie down a judge? Because judges come in all colors and all shapes and size. There are 2 or 3 things for tying down a judge. Number 1 is citation. If you produce citations of the Honorable Supreme Court or of your own High Court, let's say on each point you produce 2 or 3, chances are if there are 8 points to be dealt with, chances are that no judge is going to have time to read 16 citations and to distinguish them. Most likely he'll be impressed by the fact that there are already Supreme Court judgments on the point. He will rely on those very judgments to buttress his reasoning. Therefore, always carry A, the judgments of the Honorable Supreme Court, B, the judgments of your own High Court. In case a point has not been decided by your own High Court, do your research properly and see whether there's a judgment of a full bench of another High Court or not. Number 2, although it is not the usual practice of the counsels, but I always suggest that you submit your written arguments even in criminal cases. The reason being, in an appeal, you may want to argue before the Honorable Supreme Court that a particular point was indeed raised, but it finds no mention in the judgment. Now, how will you prove that before the Honorable Supreme Court? Your written arguments. Your written arguments are part of the judicial record. Therefore, you can say that please turn to my written arguments that I had submitted before the Honorable High Court. This point was indeed raised. It was discussed in my written argument, but does not find any mention in the judgment. Therefore, the judgment deserves to be set aside. The other 2 things is, of course, do not relate to criminal appeals, but come in very handy when we are arguing a writ petition. If you really want to ensure that the court does issue a notice in the first day when the matter is listed for fresh admission, many counsels apply this trick. Either they raise a constitutional issue. Once a constitutional issue is raised, the judge cannot dismiss the writ petition in the first hearing. He has to have a full-fledged hearing on that constitutional issue. Or many tax lawyers do it, many clever lawyers do it. They raise the constitutional validity, the issue of constitutional validity of a statute. Once the constitutional validity is challenged, no judge would have any other option but to issue the notice. because the constitutional validity cannot be decided ex parte. It cannot be decided without the assistance from the side of the state. It is the duty of the state to defend the constitutional validity of a statute. Therefore, we have no other option but to issue notice in such a case. These are the ways. I hope they will certainly help you in preparing your criminal appeal. I hope you will gain from this lecture and you would keep in mind the points that I have mentioned. Thank you very much. Jay, any questions?
So first of all, I have to say that this is one of the finest sessions that we've recorded on the Virtual Amicus so far. I started this channel exactly a year ago in the month of April last week during the COVID second wave, sir. And I've been doing this over and again, but this has to be undoubtedly one of the most informative, enriching sessions, enlightening experience, and an eye-opener in many ways, because the tips that you gave, the valuable insights that you shared with us, I mean, I'm going to here to stay, and I hope that all the viewers who are watching this will imbibe them in years to come. So thank you so much, sir, for taking our time for doing this.
That's very kind of you.
Sir.
No, that's very kind of you to say all this, but this is what my experience as a judge has been.
So I had some 5-6 questions lined up, but I think you've answered more or less all of them. Just one question, sir, you have a phenomenal command over English language. I mean, I don't need to comment on the legal acumen because you've already done that through this episode. But what books would you recommend to all the young lawyers who aspire to have such command? Legal acumen obviously takes years and years of practice. You develop it over a period of time, but that only happens when you become a voracious reader, which your lordships are, sir. So any good books that you would recommend for young lawyers?
Before we talk about the good books, let me just clarify a doubt. Many of us who are not from English schools, but are from regional schools or Hindi medium schools, unfortunately, we tend to suffer from a mental block. The first thing to understand in one's life is, please get rid of that mental block immediately. And the reason being, Hindi is far ahead of the English language. The complexity of Hindi can never ever be imagined by the English speakers. Hindi has more vowels than English. English has 5, we have 14. B, English has pronunciation that Hindi has pronunciation that English never would. For example, we have compound sounds. Take my own name, Raghavendra. That dra can never exist in the English language. Therefore, it's a misnomer to think that because I'm a Hindi speaking, there's something wrong with me. No. In fact, you're far ahead of your English speaker, far ahead of your friends who are, speak good English. The only thing is we have to understand our Hindi the way it should have been understood. For example, Hindi has a clear-cut distinction between va and ba. But when you speak to a Bihari friend of yours, he'll always say very, very good. Even a Bengali will say very, very. He has not understood the word. The letter V is not a ba. It is va, as in vakra, as in vakt. Therefore, if you understand the pronunciation in Hindi, you can never ever go wrong in English. And let me tell you, when I went to United States in 1971, I had no knowledge of the English language. The first sentence I was taught by my father was on the plane, and all he taught me was, my name is R.S Chauhan. So even when I was asked for the first day, what would I want for dinner? I said, my name is R.S Chauhan. But what convinced me to learn English was 2 facts. Number one, we are way ahead linguistically. B, there's nothing so unusual about English. In fact, it is a confusing language. Look at its spellings. Look at its pronunciation. Polish and polish, 2 words. Spelled differently, pronounced same. Now, how do you have a language that is so confusing in itself? So what's so great about English? It's just a ho-ha that people have created throughout the world that English is the best language. No, sir, it is not by no means. Half our regional languages will beat English hollow. Even Bengali will beat English hollow. Kannada will beat English hollow. So please get rid of this mental block that all of us suffer from. Number one. Number two, there are excellent writers, but when you start reading, don't read novels. Novels can be very heavy in terms of volume, in terms of pages. Don't begin with War and Peace by Tolstoy. That runs into 400 pages. Who wants to read 400 pages? Begin with short stories. And they're lovely short stories. R.K. Narayan's Malgudi Days, which I'm sure many of you must have seen the TV adaptation of the Malgudi Days. Begin with short stories, and they're fantastic short story writers. And not only in English, even read Premchand. You want to know what India is? Please read Premchand, read Minto. They will tell you what India is. They will tell you what village life is. They'll tell you the experiences of life. And then begin with the small, what we call novella. For example, read The Alchemist. Amazing book. It teaches you a philosophy about life. It tells you, do not hate your enemies, love them, and love them dearly. They're the people who taught you how to live life. Your parents didn't teach you how to live life. They protected you from every side. Your friends never taught you because they too protected you from every side. But your enemies, they exposed you to the difficulties of life. They brought such terror, such traumas to your life that you learned how to deal with life. You got up on your feet, you fought, you gained confidence. So therefore, Pablo Coelho has a fantastic philosophy. He says, love your enemies. Why do you want to hate your enemies? And then read biographies or autobiographies of the great human beings. For example, there's a book by Sudesh Pai Saab on the leading lawyers of India, the leading judges of India. Read them. You'll learn so much from their life. And you will realize that you're on the same journey, on the same path that they were. And if they could achieve it, so can you. It will instill a sense of confidence in you. Read R.K. Narayan, read Chetan Bhagat. They're great writers who have a great command. Shashi Tharoor, I read practically every book of his because I find him as one of the finest English writers. Even a book I would highly recommend to all of you, Guru Charan Das's book, The Difficulty of Being Good. Amazing book. Because what Mr. Das has done is, he's taken all the major characters of Mahabharata and analyzed them. And you need to analyze the witnesses. You need to analyze your judges. You need to analyze your colleagues. And what he shows is that each character, although we may consider those characters to be villains like Duryodhan, yet there was a logic. And when you look at the logic of Duryodhan, you realize he's absolutely right. He's not wrong. Therefore, he's not a villain. He's a hero. And he puts the entire Mahabharata on its head. In fact, if there's one book I would recommend everyone, although it is prohibited in Hindu families, and I don't know for what reason we have prohibited this book, read the Mahabharata. It is the most complex book ever written by human beings. And if I may say so with all sense of humility, even the best of Shakespeare's work are no match for Mahabharata. Mahabharata, each character is so complex. Each situation is so complex. And you will understand what happens with a human being. You'll realize, and now read the latest interpretation of Mahabharata which are coming into the market. For example, read Mrityunjay in Hindi, which is looking at Mahabharata from the point of view of Karna. Read Valmiki's Ramayana. Please do not read Tulsidasa's Ramayana. Tulsidasa's Ramayana, with all due respect, is a watered-down version of Valmiki. Valmiki's Ramayana is more powerful. And read the interpretation now of Valmiki's Ramayana. For example, to the lady lawyers, I would say, Read the latest book to hit the market called the Valmiki's Women. I believe it is written by Nandi Karan, the same gentleman who has written the novel called Asura. Read those about those women. Read about what is the interpretation of Kunti. What is Draupadi? Who is Draupadi? We talk about women liberation. We talk about women empowerment. We have the most powerful women characters in our Sanskrit literature. So read those books. Even if you want to read them in English, please do. Fantastic, translations of all these classics are now readily available. But the more you read literature, the more you read history, the more you read the Puranic myths, because many times you can make a point and convince a judge. And I'll give you just a small example. Once I was arguing before a learned single judge in Rajasthan High Court, where my opponents were all the leading senior advocates of the High Court, practically all of them. And I was all alone trying to defend the JDA in a case, the Jaipur Development Authority. And I had to somehow win the sympathy of the judge. Now, how do you win the sympathy of a judge when you're fighting against all the senior counsels of your court? So I just began, my opening sentence was, "Sir, today I stand as Abhimanyu stood." That's it. You made your point that you are the underdog. You are the brave man who is standing against all the great warriors of the Kaurav army. So the judge was brilliant, as he certainly was, undoubtedly one of the most brilliant judges we had in the Rajasthan High Court. He said, "Oh, Mr. Chauhan, you are branding them as Kauravs." I said, "No, sir, I didn't say anything. I said I stand as Abhimanyu, that's all." But by pointing out to the judge that you are the underdog, you have consciously, unconsciously tipped that scale in your favor. Therefore, know your Puranic stories, know all your stories from all the mythologies. Many times, mythologies teach us the wisdom of our lives. So I would emphasize that please read all your mythologies anywhere, whether they're Christian myths, whether they're Nordic myths, they're Egyptian myths. You will be so well versed that judges would love to hear you in the court. Because many times you will be, and this is not something I'm saying, this is something that President Abraham Lincoln had said. When people asked him, "Sir, how do you," and please remember, Abraham Lincoln was a lawyer. So people asked him, "Sir, how do you persuade your generals in the middle of the Civil War?" He said, "Very simple. I just tell them the stories from the Bible. Or I use my wit." Once somebody complained to Abraham Lincoln that this general of yours is an alcoholic, therefore please remove him. He said, "Please find out which brand of alcohol does he drink. I'll send it to the rest of my generals. This man is the only one who is winning the war. Rest of you are losing. I'll make everyone drunk on that particular drink." So wit also comes. For wit, read Reader Digest. Reader Digest has 5 columns just on sense of humor. Something that we tend to ignore these days. Unfortunately, even the bench has become at times too serious. I wish our bench would loosen the collar and would learn to know what wit is. But wit used to be, at times, the backbone of the British judiciary. And we know many of our leading lawyers in the olden days, like Mr. Sapru, was known for his wit. He could put even an English judge in his place. But be careful when you use a wit. Please know your judge at that time. Look at whether he has a sense of humor or not, because the chances that it may just backfire. But read anything, any magazine, all the newspapers, read about related topics. As I said, read about medical jurisprudence, read about toxology, read about ballistics. And the wider your horizon knowledge is, there are 2 things that you will gain. Number 1, you'll understand how to present a case much more in detail in a better manner. Number 2, you will be the favorite of the bar, because you can regale them with the stories that they've never heard of. And you certainly will be the star of any party you go to. So read whatever you can lay your hands on.
Very well, sir. Thank you so much, sir, once again for making this a memorable session. It was an absolute treat recording this session, and I'm sure all our viewers will, must have, will immensely benefit from this session. So, sir, thank you so much for your valuable time.
Thank you for giving me an opportunity. Thank you for inviting me, and best of luck to your this particular endeavor, which I highly appreciate. I think it's an excellent thing you're doing. So please keep up the good work.
Thank you so much.
Thank you. Thank you.
Thank you, sir.